Welcome, everybody. We're very happy to see you to our webinar, Compliance in Law Firms, Local Standards, New Trends, and Expectations of International Clients. The world has changed, and we will not talk about Corona, COVID. The world has changed, and notably our legal profession. On one side, we all notice a strong trend for deregulation. Our competitors like auditing companies, consultants, etc. are entitled to provide legal services, even though they do not have a specific bar. The bar in a country like France, where I'm from, is like the Catholic Church, organized the same way. The head of the bar, a bâtonnier, is the one having in his hand the stick of the bishop. Yeah, so that's a tradition where we come from in a country like France, and the trend is different with regard to the regulation of our profession as such. On the other side, our clients, and notably in the banking and finance sector, have been subject to strong increased regulations. They know subjects like KYC for a much longer time than us. Whereas lawyers are able to prepare the documentation for setting up a company within a couple of days, if you ask a bank to open a bank account, it may take months because they need to run the KYC. Our profession as such has adapted, and we benefited of this over-regulation of the banking sector and developed activities like compliance within our law firms. This is not the subject of this webinar. We will not talk about compliance subjects for our clients. We will talk about us, compliance for law firms. So we will discuss a couple of subjects like the organization and compliance in law firms. How is it organized? How do we manage conflict of interests, and what are the main subjects there? How do we secure confidentiality of our clients, and what is our exposure to cyber risks? And how does it work to run properly a KYC and to comply with AML process rules? Let us briefly introduce our speakers, and I will start with our co-moderator, Ilona Zekely, Austrian grown-up, educated, well-known international lawyer, having worked and practiced in Eastern Europe and for years now in Russia with EPAM and heading the international desk there. Ilona, I hand over to you.
Yeah, thank you very much, Karl. Maybe as well a short introduction to the webinar. I just want to give a brief information that this is a webinar, one of the online pre-conference talks related to the 15th IBA Annual Law Firm Management Conference, which will take place in Moscow on December 3rd this year. So who has not yet registered, we herewith invite you to do so. A special thank I would like to say as well to the chairs of this conference, Vladislav Sabrodin, who is the managing partner of Capital Legal Services in Russia, and also Soya Ilyenka, who made this webinar possible. So now I'm glad to introduce you to our international and highly recognized speakers. Among them is first Audrey Chen. She is a partner at the leading law firm in China, and she's a member of the IBA Law Firm Management Committee too. Audrey joined Junhe in 1993, almost 3 decades ago. As an attorney admitted in the US and in China with cross-border experience, Audrey is a well-known M&A lawyer, has done many high-profile deals. A few of them were deals of the years in the global M&A circle. Audrey is on her firm's compensation committee and a partner review committee. We hope Audrey can shed some lights for how law firms have been run in China. We don't think we have similar level of media coverage or understanding as we do for the European Union or US law firms. Then we have Marc Jones, who is the Director of Risk and Compliance at Travers in London, where he acts as de facto General Counsel to the business on conduct, risk, and regulatory matters. Marc has spent most of his career defending malpractice claims against law firms, and now enjoys looking after the risks and interests of Travers Smith. Then we have Martijn Lesterhuis, who is a partner at Venturis Consulting Group, a strategy and management consulting firm focused on the legal industry. He advises law firms, ELSPs, and legal departments on strategy and transformation. Martijn is not only an advisor, but he has been as well 25 years in the legal and consulting industry. Because before joining Venturis, he was a lawyer and also the managing partner of the leading Dutch law firm Van Doorn. Now he's a strategy consultant, and he was also working before with Boston Consulting Group and held as well senior corporate and transformation roles within different industries. So we will be very much looking forward to hear Martijn to talk about our topic today. Then we have Alexander Schwarz, who is a very well-known partner and M&A lawyer at Gleiss Lutz. He's not only a partner there, he's also the co-managing partner since many years. And he was advising on the largest and most complex M&A transactions in Germany with international angle. He's also active within the IBA for more than 25 years and currently the member of the LPD Council at the IBA. Last but not least, we have Martijn Simovart. He's a partner at Cobalt in charge of M&A. And Cobalt is one of the leading law firms in the Baltic states. He's also the member of the management board at Cobalt and the head of global relations and responsible for its international reach at Cobalt. He has also more than 25 years of extensive experience in complex multi-jurisdictional transactions and is advising industrial clients and private equity sponsors. So this is our distinguished panel. And finally, I'm glad to introduce you to my co-moderator, Karl Hepp de Sevelinges, who is the co-managing partner of Jeantet, which is one of the leading French law firms, which has as well a presence in Ukraine and Russia. He is the partner at the corporate M&A practice, and he was also in the past the managing partner of one of the leading French law firms, being based in New York City and as well in Kiev. So, Karl, I understand you're going to introduce now our first topic.
Yeah, so when we talk about compliance, the first question is how is it organized and how do law firms organize compliance to comply with the rules that are imposed to law firms. We have Martijn Lesterhuis and Alexander Schwarz, who will talk and introduce the subjects and be available for a couple of questions. We have always to bear in mind that we are presenting here the organization of Western European law firms of a certain size. I imagine that transposing such structures in smaller boutique firms may be more complex, and maybe we give it some thought as well, how they can deal to comply with these complex questions. But I hand over to Martijn to introduce to the subject and present how this is organized. Are there any requirements to a team? Is it external, internal? Can we use some tools, or are there some tools available on the market to assist us and support us in doing this? And what are the new trends? So Martijn.
Thanks a lot, Karl. Good morning, everyone. Yeah, a very pleasure to kick off the content part here. So what we want to discuss first is, if you look at the organization of compliance, or actually what are the areas that need to be covered if you have a feeling about compliance. So what does it all mean? And basically what you can look in it's mainly three areas. So you have the areas which are client related, And then you need to think about know your customer and anti-money laundering procedures, conflicts of interest between clients, and maybe also sometimes what you do is credit checks on your clients. So that's really the first part. The other part is much more matter related. So when you actually look at the case, what you're doing, so you need to think about insider trading rules, maybe ethical walls as well, what used to be called in the past Chinese walls requirements, and especially what is becoming increasingly more important are mandatory disclosure rules. So that means what we call the DAC 6 regulations, which focuses on international tax aggressive structures. So that's much more we need to think about on a matter perspective. And then, of course, you have compliance regulations that are much more firm related, so much more in general, not only on clients and on specific matters, but what relates to the firm. GDPR has become very important, so privacy regulations, what do you need to think about and how do you need to organize it and protect your data. And if we already look a bit at the trend, what will be coming are much more, especially what we see in Europe, is much more ESG related requirements. So you need to think about in the future that as law firms as well as any other company, and GDPR is also something that doesn't apply only to law firms, but in general to everyone. You need to think about reporting requirements on what you do in terms of environmental and social impact and how you organize it. So there is already a lot of regulations coming on law firms and more to come, especially what we see is being driven in Western society. So that's basically, if we really look at compliance itself. Outside of it, and something we're not going to focus too much today on, is IT compliance and security. Which is very important as well, and financial compliance. So think about how you avoid fraud and theft. So I think in terms of organization of compliance, the areas that you need to cover, these are mainly the important ones. Do you want to add anything on that, Alexander, or?
No, I think the areas are fully covered. So as Karl said, probably the client related ones are, we don't speak about our client needs, but this is an important one for everyone involved. And I mean, adding on the team, I'm just following up on what Karl says at the beginning. This is a question, who is responsible for compliance and who takes care of the whole thing? And this is certainly a matter of the size of the law firm. My firm, we are about 400 lawyers now, but we have the same problems as another firm with 5 lawyers, because at the end of the day, it comes down to what every law firm has as a problem. The partners, the lawyers, they say, leave me alone with this at the first step. They said, oh my God, more and more is coming. Who shall take care of this? This is making my life difficult. I don't want to do this. I don't want to spend 2 hours on opening a file. I don't want to spend 5 hours on a know your client procedure. And then it comes up to the question, okay, who shall take care of this and how do you deal with this? And with the compliance in the last few years, the matter has become serious, and every firm in the world has realized that we just cannot leave people alone and are dependent on the thoroughness of the partners doing with that, but we need to somehow centralize this, because there is severe sanctions, there is fines out there, and if you don't comply, you might be in deep S if you just fail. So the question is that going to be in my role, the managing partner who takes care of everything? Do you need specific people, maybe external advisors? Do you need a general counsel even? Or do you need a combination of all this? What we have done growing as a firm also in the last years is, first thing is, I think, which is important, the tone from the top in compliance is very important. So there needs to be a specific or the managing partner or one of the responsible partners needs to have, I am the chief compliance girl or guy, and you listen to me because this is an important topic. And this you have to reiterate like every second day, because otherwise people just tend to forget about it. That's the first one. Second one is, it's really complex. So I'm not in a position to be an expert in all the fields. Martin was mentioning it comes from tax-related matters to know your client matters. It's going from cyber things to other things. So as a trend, and I think Marc Jones will say a few words about that later, we have found out that we need to have one key responsible person. You might call him a general counsel, or you might call him a chief compliance officer, but starting from a certain size of the firm, you need to have a top professional within the firm. And then the professional might be supported by a team of other lawyers, a team which is, we call it the legal operations teams, which is composed of also cyber people, people that are not necessarily lawyers. Some of them are, but some others are not. And then you make things somehow round, and sometimes you need to rely certainly on external advice. You need to rely on help with the IT perspective. But in general, my message is tone from the top is important. Don't leave people alone, but take this seriously, because the consequences out there are kind of severe, and we cannot just people who are only interested in doing client work alone with the whole topic. But this just as a kind of a message from which I would also tell my own people all the time. Yeah.
Maybe if I can add to that, because I think what Alexander is saying, that's actually what we see in general is a trend, right? So because it's quite complex, we see most firms really starting to think about, okay, we do a complete central client intake, and it's not only the really large firms or the international firms who've organized this already in the past, and I think Marc can relate to that as well. But we see also middle-sized firms who are moving to that area. So because it's becoming complex, because you need, at least in Europe as well, you need to have somebody at board level being responsible for this, and it's taking so much time. Lots of firms are saying, okay, what we do now is, because it's becoming complex and we don't want to bring the burden to our partners, what happened in the past, we organize it centrally, and we organize it whether it's internally or we hire somebody externally to help us with this. That depends a bit on the organization, but really to guide the client intake and the matter intake through a standardized process. And you just deliver as a partner, you deliver the information that is relevant. You have other people who basically organize everything. That helps, by the way. Also, what we see a lot of firms is they take the opportunity, because it already starts there, to take other processes in the organization as well to make it much more efficient. So there is also a positive side on that. Yeah.
And are there any tools for that?
Yeah. To be honest, I think what we explained just yet, if you would do this manually, it would be impossible. Yeah, you see a lot of tools coming in, and also on the different areas. So there is, let's say, what you need to be aware of. There's not one magic tool that covers everything. So we see a lot of different tools, whether it's on AML. So we see the large companies like Acuity, LexisNexis, WorldCheck, those types of providers with large databases that you need. But of course, apart from the databases, what we see is people in the compliance team do also internet searches. So that's also there as well. But you need your internal search tools on your PMS system, or for your conflict checks. Sometimes you see firms still sending around emails to the partners, but you know, that's becoming much more difficult. So that's being advanced. DMS systems with proper role assignment, especially on insider trading rules, and you need to think about these kinds of things, and also on GDPR. I think so for everything, basically, you see there are different tools on the market, and you actually need them. I think maybe Alexander, can you relate to that? What you see within your firm?
Yeah, sure. I'm not a tool expert though, because that's really complicated. But the starting point here again is, and this is what we have found out when the topic became more serious. It's difficult for a firm that has grown over the years what is the set of rules for compliance? This is an important one. And we found out that we had a lot of compliance rules which had to be followed internally, externally, but nobody knew where they are. We had kind of a handbook which was written by generation and generation. Some of the rules were from the 70s, some others were from yesterday, but still there was only at a certain stage, there were only a few persons who had been with the firm very long, for a very long time, who said, okay, but there has been, our board has decided on this 5 years ago, and the other said, but the managing partner at that time had sent an email to that. So we had to say we have to combine that. And the key of the compliance rule is that we have created a so-called an app at the end of the day, which is called Gleiss Lutz EO2, which combines, it's a little bit of a Wikipedia of the firm. It combines all the rules we have. You just type in whatever client engagement process, or you type in holidays, and then it will give you, okay, the lawyers have 25 days of holidays. Everything that is a rule within the firm is within that app. And this is the basis of everything. And as Martin has said, for other things, business intake and so on, there are specific, let's say, IT systems. Sometimes for us, the decision has always been, do we buy something in the market? There are great systems out there, but not all of them are really adapted to our needs. So we have always gone the way that we have developed our own IT together with our internal department, who knows what people are doing and who knows how little time people would like to spend, and then combine it with IT experts and create something own. But at the end of the day, there needs to be a person again. So for example, for matter intake, there's a system and this does everything, but at the end of the day, we have a committee, and then the human factor comes in again and says, this can go, this we cannot do, and this is a matter we don't want to take because of this and this and that. So the human factor at the end of the day has to come back, and then you try to have a round picture.
Okay, so let's take an example. If you identify that the client is a politically exposed person, what happens within your firm and what will be your decision? And he's coming with a great mandate to take over Siemens in Germany.
Same as I said, there is kind of a intake system which has all the, from money laundering to also, yeah, political questions. It might be industry questions. Do you want to be involved? It might be countries, it might be political situations, it might be industries, and so on and so on. So there will be a kind of an alarm. And then it goes to a small committee which says, okay, but we have been acting for them for quite a while. We need to be a bit stricter with the anti-money laundering, or we don't want to act for an industry like, to take an example, which is totally outdated because we do that all the time. But 10 years ago, the first people were coming on the cannabis industry, and everybody said, oh my God, this is drugs and this is forbidden and we won't act on this. The Dutch are laughing, I know, but for us it was, shall we really act for them? Today, certainly we act for them, but at that stage you said, is that something you would work on? Sometimes you have the question with probably military industry, but at the end of the day, certainly we would also, but you have a look at the person, countries, is this somebody from the Cayman Islands, and then the whole thing starts going up. But it's the humans deciding. There is no system, to answer your question, Karl.
Thank you. And the difficulty is often to get people on board for this. You already mentioned your great app, yeah, in which you can type in questions. But how do you ensure that your lawyers and your partners comply with all that, and how do you enforce it? Yeah, would you fire a lawyer within your firm who does not comply with your internal rules?
So far we did not need to do that, but at the end of the day, I mean, it starts again. We keep telling people all the time, every partners meeting, every associate meeting, we start off with that. It's about getting into the heads. But I think, and then the consequences for that, it's a bit difficult, but normally, as soon as it gets to your own money, people start complying. So what we are thinking of is, if you're not compliant on a matter intake, then you just don't get paid travel cost, for example. It's very easy. If a matter is started and it's not in the system, and somebody was traveling to Moscow for a business trip, and you tell the partner, yeah, but the matter has not been in, we're not going to pay for your travel costs. Suddenly they will be compliant from that date onwards. So if it goes to the own money which they earn, it's normally the most efficient system. But Karl, this is an example, and it is really, really difficult to enforce compliance in that aspect. I fully agree, because everybody thinks I'm the greatest lawyer in the world and they should leave me alone with that, and I do whatever I want, and it starts by telling people all the time. But Martijn, I have no secret recipe on this. Maybe you're more advanced here.
Yeah, no, I totally agree with you. It's a bit difficult, of course, because sometimes what you're doing is you're entering into new territories, and people need to change and follow the rules. What of course happens a lot is when hopefully not yourself, but another firm or any related industry, there is a huge problem or a huge mistake, then people wake up and understand what has happened and also what the consequences are. And usually that's also a way to wake up. So that's maybe not the way you want to do, but usually what you see in countries, something happens, firms see what is being done to a reputation to the firm that is in problems. Suddenly everybody wakes up and realizes and say, okay, we knew it was an issue, but actually now we're facing it today. What really happens, this could happen to us as well. We need to step up.
Martijn,
So
are there any examples of cases that put law firms in difficulty due to not complying with certain rules?
Yeah, I think just look, and I think every country has its issues. And just looking at the Netherlands, a few years ago we had the Panama Papers. There was also a mid-sized firm who just was involved in setting up structures, actually against quite low cost, and they were huge in the news. That had a huge reputational effect. So all the other firms are looking at this and say, look, if we look at what we're earning with this and what we're involved, we really need to step up, because as a reputation, it could kill us as a firm. And maybe on another matter in this stage, but then I really look at what happened quite nearby myself. So we have the state attorney in the Netherlands who is involved in fraud problems, where actually the state was involved as well, and it was the former managing partner. That's a huge scandal. That means that everybody within the industry, the law firm industry, is now looking at their processes and say, look, this could kill us. So yeah, and I think I can imagine every country has this.
Okay, thank you very much to both of you. I think we could continue during the whole webinar just discussing organization and different subjects of compliance. I hand over to Ilona to address the next interesting subject.
Yeah, the next subject is conflict of interest. The duty of a lawyer to never act where there's a conflict of interest is one of the most, I would say, fundamental duties a lawyer owes to a client. And it is the one that introduced challenges for law firms across all the globe. These can be either client conflicts, own interest conflicts, commercial conflicts, or also personal conflicts or political conflicts. We have now Audrey, Chen, and also Marc with us to discuss some of the key issues that arise in China and the UK in this regard. But before we dive into some of those broader issues, I was curious to hear from Audrey a little bit more about the experience of Chinese law firms. Audrey, as the world's second largest economy, China's growth creates huge demand for legal services. However, we hear from time to time that the majority of Chinese law firms are using a commission-based model, and they don't run conflict checks in the same way what international law firms do. Is that correct? And if so, how they deal, and also how does Junhe run the conflict checks in order to comply with international standards? So
thank you, Ilona. Yeah, thanks.
Audrey.
I think the situation we have in China might be slightly different. You're right. In China, people will comment like over 90%, if not more than that percentage. This law firm are operating a typical model, which this lawyer only share the rental or office overheads. The partner can use the law firm's name or logo for external purpose. Internally, the partner or his or her associates are totally independent from other partner or their team. So from financial team manager aspect, the partners is herself or himself decides how many office cubicles his or her team need from the firm, which associate to hire, how much they pay for each associate, and whom to promote. So under this operation model, the partner or the respective team are in substance are independent law firm. Under this model, it won't be feasible to ask the one firm, one partner, to not representing the client just because you next door or next office cubicle law firm act for the existing clients or other side. For that situation, I think this structure or this model determines the Western conflict check rule won't be really practical or feasible in law firm in China. So, Ilona, you are right. It is correct. Most of the firm, they don't operate or run the conflict checks in the same way as international law firms you often see. And people are familiar with Chinese firm often commented that maybe only around a handful of law firms are fully integrated and run as the same approach as the Western law firms has been doing. For our firm, at the Junhe, we have almost 300 partners. As a fully integrated law firm, the conflict is required to run upon the first email contacts by the clients. So we have a conflict check committee and the conflict check admin team. We have quite a few forms every time you need to fill in. So you got a client, potential client, or if the client has a related party, counterparty, any counterparty, parent company, subsidiaries, and more importantly, what kind of mandates. They are potential dispute or just normal corporate or advisory work. That's very important as well. Once you run the conflict check, you will see past the dealing of for this potential client or counterparties, and when was the last day the billable hour has been registered in the system. So quite a lot of information. Then you can decide you have a conflict check or not. For our firm, some of you guys might know we are MA focused firms. We work with international firm and domestic overseas clients all the time, and we run exactly conflict check system is exactly the same. For this jurisdiction, multi-jurisdiction transaction, it's not unusual for us approached by the both side client, but in that case, we adopt the basic simple rule, first come, first serve. But I think what our co-panelists discussed before, compliance issue is sometimes is a hurdle or add some extra value for our firm, because for a partner, for such reputation we have, sometimes actually work against us. Because I also own our firm, partners review committee, we do quite a few a lateral hire. But for our reputation, lots of partners, before they join us, they want to run a conflict check to see whether it's be feasible, if they won't be conflict out, but once they join the firm. But without such a stringent rule as I described, we just have to sorry to see quite a few teams we found they could be a very good fit for our firm and created quite a lot of synergy. They ended up not joining us. But I think economically is very convenient. You get like become larger firm, but sometimes just the price we have to pay.
Yeah, I think this is similar in other law firms as well. Yeah, Audrey. Then we have another topic to discuss. It's about the exclusivity of representation, because sometimes clients are asking you to exclusively work only for them. How does Junhe deal with such requests, and when it deals then with such business conflict requests?
Yeah, every time people ask that, I think that will bring the tears to some of our partners, because one good example is the Alibaba. We all know they are humongous companies, quite a lot, significant amount of legal fee. Years ago, the Alibaba did approach our firm. They asked us to drop all their competitors to be exclusive representing them. Of course, that's quite a economically, that's a significant amount, not mentioned from reputation boost. But after quite a lot of discussion internally, we decided to keep the existing clients, so we end up not to working for them exclusively. But the good advantage is we work with all the firms, which became the counterparty of the Alibaba. But I think for a situation like this, it's always the painful process for the partner in charge, for the client, because they spend so much time, so much efforts to win the client over, then get conflict out. I'm also on our firm compensation committee. We probably need to think about that. If Karl, if Accenture has any tip for that, I would love to hear. So how to compensate your partner whose clients, major client, got conflict out. But in any case, we were just thinking, it's very easy to say when you see clear white, this is an ethic problem. It's easy for us, for lawyer, make a right decision. But sometimes it's not so clear. When I talk some major Korean firm, their founding partner made always, for a few key milestone cases, they've always made the right decision, such as choose Apple or the Microsoft years ago. I think that's the highest of a state art we probably have to learn and to equip ourselves. I think that's quite an issue. I think from the Marc's John's perspective, he might have something to introduce us from the UK perspective.
Yes, thank you, Audrey, and thank you first of all for having me. It's a pleasure to be here. Everything Audrey's spoken about really does resonate with me as well. I mean, I'm sure many of you listening today will have fairly sophisticated clients or demanding clients, and certainly we see prospective clients these days trying to get us to subscribe to very onerous contractual terms when they instruct us. And there are three that really stick out for us, I think, in the UK. The first is to accept instructions with no contractual liability cap in place, meaning that when you're acting on high value transactions and that sort of thing, you are quite exposed. The second, and we'll come to this a bit later with Alexander, is to subscribe to very onerous information security requirements. And then the third is precisely what Audrey's just been talking about, which is not always, but quite often, we see it particularly with financial institutions, this commitment to never act adverse to the client. This might be one of two things. It might be a commitment to never ever act adverse to them on a contentious matter or even a transactional matter, or it might be only on a contentious or litigious matter. I think it goes without saying that most of us, our default position would probably be that, well, actually, we don't particularly want to act adverse to our clients anyway. We don't particularly want to sue them, and we want to look after them and be loyal to them. But the reality is, the commercial reality is that that loyalty is not always reciprocated. And you do come across instances where, for example, you agree with a client that you will not act adverse to them. You get one or two small, not so interesting instructions from the client and find out that elsewhere in your organization, perhaps your litigation department, you're turning down more substantial work to sue those clients. So as I say, it's not the natural instinct to want to act adverse to your clients, but there are those clients that will appoint every other firm in the city or on your area or your region to make sure that they conflict every decent law firm out there from acting against them. So this is a reality that we're faced with. So, I mean, what do you do about this one? I mean, Audrey's explained very well how they approach it, and our approach is not dissimilar either. We will have a conversation about it, and what we'll do is we'll look carefully at those terms. We do subscribe to them. There are clients that we agree to act exclusively for. Of course there are. But before we sign up to those terms, there needs to be a conversation with others in the business. We talk to our dispute resolution department in particular, just to see whether it's likely they could receive instructions to act adverse to those clients down the line. And is it a good idea that we actually commit? Because I think our ethos here anyway at our firm is once you've commenced that relationship with the client, you want that loyalty to last, and you know, irrespective of whether there's that exclusivity or not. So absolutely, Audrey's experience is very, very similar to our own, and certainly our approach is very similar.
Great. And we have heard now how, you know, conflict checks are done and how you deal when recruiting partners from other law firms. But my question would be now, in terms of personal conflicts, how do you deal with this, and how UK law firms are considering and how it is addressed within Travers and Smith?
Yeah, this is a really interesting subject in the UK at the moment, Ilona, and it's a conversation that started originally, or it was born out of the Me Too movement, because it was discovered that, I mean, we've known this always, haven't we, that within law firms there are many, for example, senior partners who are in romantic relationships with more junior people in their organizations. It's an inevitable consequence of working long hours. I mean, when people work together, that's just something that's going to happen. And our regulator in the United Kingdom sums it up quite well, actually. They say they have no interest in interfering with the work of Cupid, save for where the arrow draws blood. And the arrow, I suppose, draws blood in those circumstances where a conflict of interest arises from that relationship, from the imbalance in that relationship. So, for example, you know, the more junior a party to the relationship might be favored in remuneration and promotion conversations and that sort of thing. I mean, but that of course is only one category of personal interest conflict. There are many others. I mean, financial interests in clients or suppliers, using client businesses, for example, to provide goods or services to your firm, relationships with those who work for your clients, and any outside activities, really. You know, people sit on the board of governors of schools and other organizations. So all these things can give rise to personal conflicts, and you cannot introduce a policy that seeks to avoid them. It's just not realistic. So what we do is, one, we recognize that we are going to encounter personal conflicts. It's just a part of life, but we call on our people to disclose them. So we have a policy now which explains to our people what we think a personal conflict is, and then we ask them to disclose those personal conflicts so that we can have a conversation about managing them. So, for example, if there is a, you know, the romantic relationship example, we make sure that, you know, the other party to the relationship is not part of those conversations about pay rises and promotions and all that sort of thing. and the moment people put their cards on the table, you can manage that risk in a careful and pragmatic way. So that's how we deal with that one.
And when it comes to board members, for example, how do you deal with that? I mean, if someone is invited to the board of a very, let's say, important company, and somehow it will not go confirm with, you know, conflict checks and other clients you serve in the firm. So do you have then some expectations or any other ideas how to deal with that? Or does the partner have then to leave the firm, or he has then to decide what to do?
Well, I mean, absolutely. That choice could arise, but you know, there will be occasions where those positions on boards are advantageous because the interests of the partner on the board and those of the client are aligned. So actually having someone who's invested in the client, I don't mean financially, but who looks after their internal affairs or has a position on a board, I mean, that's a good example of an alignment of interest. So you might actually seek those sorts of appointments out. You might actually try to make those sorts of appointments possible. But you're absolutely right that there will be some where the consequence of the appointment to that board is negative. And again, it's all about disclosure, Ilona, asking partners to flag these things with us so that we can make a decision, and we would then mark those appointments on our conflicts database, so that whenever we run a check against that particular entity, that appointment is known to us, it's captured, and we can see it and we can manage it.
So transparency, I think, is the key word here, right?
Absolutely. And you're at the mercy of people being sensible, but there is an education piece, because it's very easy to overlook this risk and not pick up these conflicts. So you're right, transparency is vital, but there is also a big awareness piece here. Yeah.
Audrey, do you have anything to add on personal conflicts from a Chinese perspective and how Junhe is dealing with such matters?
Yeah, for the board, I think for that, anything like any partner take any board position, they need to register with the firm first. But we just had the partner meeting in September. The recommendation is not take any board position because whole firm will cut conflict out. So
I understand. So I think we could talk more and more about conflict of interest and this topic, but as we do have only limited time, I pass on to Karl, who is now talking with the panelists, Marc Jones and Alexander Schwarz, on confidentiality and legal privilege.
Yeah, thank you, Ilona. In our introduction, I talked briefly about the Catholic Church. We're talking now about confidentiality. At the times, at least, people went to the priest to tell him everything, and they could rely on the confidentiality. Lawyers were supposed to be similar, probably not the same secrets, but some of them. How is it today? Yeah. Can you still trust your lawyer, and how do you handle this confidentiality obligation that you have in your direct relation to your client, and is the basis of the relationship in light of DAC 6 and other regulations and pressures or status of the lawyer? Yeah, is the lawyer really so close to his client, or are there situations in which the lawyer has to become a whistleblower? So what is a trend, and what's the situation, and do you really think that this confidentiality principle is threatened? Marc and Alex, what do you think? Maybe Alex, you want to start about your feeling about the trend and how this is current and where we're going to, and if there are any limits to it. What's the situation like?
Yeah, I'll leave that to Marc later on, but just I think the priests are gone. Yeah, That's the problem. We have been educated to have a really strong and a good relation with the clients and be their closest contact. And now the trend is the state, the legislator is trying to get involved in that relationship. And well, this is the first part. This is, I think, DAC 6. This is anti-money laundering, where the lawyers are expected to be gatekeepers to the financial system, where they are expected to be kind of, let's say, helping the prosecution in telling what their clients are doing. This is really a trend which we look at with some concern, because it is totally different from what has happened before. Now the lawyers are supposed to help the state to find out what is going on in the system, as we said, tax evasion structures, anti-money laundering. That's the one. And the other one is something where we maybe from time to time bring into danger the principle of confidentiality. Also, we are now, maybe we'll have a few words about this, we're all working from home now. Can we ensure confidentiality? There is cyber risks out there. What do we do here? But this just as a kickoff. So as you said, the Catholic Church is not as Catholic anymore, and it's because of outside influences. But Marc, you are the real expert on this.
Well, I agree with you, Alexander. I think the priest dynamic has probably gone now. Can you trust your lawyer? My view is, well, certainly from an English law perspective, I think yes, you can. But there is no question that we're seeing confidentiality becoming increasingly subject to exceptions imposed by law. I mean, Alex, you've referred to DAC 6, which is a pain in the neck for many of us, which is DAC 6, for those of you who don't know, is a piece of legislation which requires law firms to report certain hallmarks that are present in cross-border tax planning arrangements to local authorities. So, you know, and that can really, you know, that example is one that quite helpfully demonstrates how that can really shift the dynamic of the relationship with the client, because, you know, you have a duty to act in the best interest of your client. You want to give them the best advice on how to mitigate tax exposure, but you also don't want to get yourselves into trouble for being party to aggressive tax planning. Is there an own interest conflict that arises there? I think by and large, your interests are probably aligned with your client, because if you do something naughty, it's probable that your client's also doing something naughty. But it does shift the dynamic, and you mentioned anti-money laundering as well, Alex. I mean, we in the UK, this has been something our regulator has been focusing on for years and years now, and they will come into our offices and they will audit our files. They will call our associates into meetings and ask them questions about matters. The auditing that takes place now is incredibly invasive, and so there are absolutely limitations on the duty of confidentiality. And of course, you know, in most jurisdictions across the globe, confidentiality will always be subject to, as I'm sure everyone knows, but the crime fraud exemption, which basically means the client can never use the lawyer to facilitate the commission of a criminal act and rely on confidentiality to avoid detection. Again, distinguishable from the Catholic priest and the person making their confession. So yeah, I mean, everything Alex says, I can only agree with.
So we noticed in the press, at least, some persecutions of officers in Germany, for example, at Jeantet, Freshfields, linked to Cum-Ex and other proceedings. So it has become quite common. It's not good press for the law firms. It does not inspire or give more confidence for the client to say, okay, we can really share our highly confidential information, and this will be subject to full legal privilege. Yeah, all this is gone. Have you, Alexander, have you any internal measures that you've put in place in case of a down rate, or at least a prosecutor ringing the bell? Is there something in place to give you immediately a call? And do you have a way to secure particularly confidential information? How do you handle this in practice?
I won't give you any details, certainly, my dear friend Karl, but certainly yes. I mean, we do these compliance manuals and anti-dawn raid manuals for hundreds of clients, in particular in relation to, as it then was, antitrust related matters. And certainly we have procedures in place that will come up if police or a prosecution is at the door. And this is, in most cases, it is not so much that, and you have that from time to time, and in most cases it's not about the law firm, but it's about the files of the clients, and certainly we need to protect them. And as soon as the first, let's say, now they are blue, the blue policeman, not the green anymore, would ring the bell and be at the reception, the receptionist would immediately know what to do, who to call. Our Marc Jones would get a call in 10 seconds, and then we have somebody at every place. And this is about protecting the files. And it's not as easy as before. As you know, before that you could say, oh, we don't know where the files are and they're somewhere here, but now they just take the laptop and everything is gone. So protection is important, but certainly we also, in cases where we believe that this is something which is in full order, we certainly also cooperate with the authorities. Clearly, yes.
Okay, so now we talked about the threat coming from the state authority. The threat to confidentiality can also come from somewhere else. That's rather new. We see cyber attacks to law firms having a huge commercial or financial impact on the concerned law firms. I think it was CMS. They were not able to work for a couple of days due to a massive cyber attack. What do you think? Are law firms sufficiently aware of this risk, and do they put in place what needs to be put in place? Do you all run cybersecurity tests within your law firms? How do you handle this subject?
Marc, do you want to start?
Yeah, happy to. Yeah, and that case you referred to of the law firm, I think it was DLA Piper who had a terrible cyber attack a few years ago, and I know that many of the people involved in that incident have aged at least 20 years because of it, and it certainly opened the eyes to the rest of us. I mean, for me, this risk is a key one, and really people like me who manage risk within law firms need to be working very, very hard on and getting senior management on board with this risk. So I'll try and keep it short, but for me there are three key aspects to how a law firm should manage cyber risk. The first is obviously risk mitigation. So having the necessary systems and controls in place to basically to avoid the infiltration of attackers. So that's the IT security measures necessary to detect these things, having arrangements with external incident response people so that if something happens, you know who to call. I mean, one of the interesting things, Karl, arising out of that DLA Piper attack was, you would never think about this, but they had a very detailed incident response plan, that firm. But of course, when that attack took place, their systems went down entirely. And so they couldn't access the plan. So the first thing you need to do is you need to print your plan out so you've got it somewhere accessible. Because when the lights go out, you're not going to be able to, that's just a little thing that you wouldn't think about. So, the other thing I think is really important is incident response readiness. So have tabletop exercises where you walk through an incident, get someone external to come in and do a bit of a role play exercise with you, and that'll really test your cyber incident readiness maturity. And then of course, avoidance is always better than cure. So heightening awareness is absolutely vital. And you know, we have mandatory training now on cyber risk. We ask people routinely to undertake that training. We also send these mock phishing emails to see if people will click on the link, which allows the threat through the door. And if they click on the link, then they have to go to mandatory training on cybersecurity. So you know, you do it that way. And actually, you know, if people are routinely clicking on links that, for example, allow threats in, you know, make that part of your appraisal process, you know, when it comes to reviewing performance. This is a risk. I mean, you've got to distinguish it from the pandemic, for example. I mean, the pandemic's fine. You can go home and you can work. But when your systems are down, you can't do anything. You're helpless. You may not even have your client's contact details. So it's a frightening situation. And your business interruption losses are going to be significant. And for those of you with cyber insurance, it's something we now have. The expectations are getting more and more demanding. You know, cyber insurers want to know that you have mandatory training, that you routinely carry out penetration tests with your tech teams and your IT support teams. But the advantage of doing all those things, of course, is that you'll achieve more favorable premiums and you'll be able to sleep more easily at night. So, but this is a big risk, no question about it, and one that we should all be focusing on.
Just two remarks for me, Karl, just two short remarks. I mean, everything is said. First one is from my personal experience. First one is, I have a reputation in the firm of trying to save money wherever I can. I'm a Swabian guy, but for cybersecurity, this is the only field where I always say we should be top. So everything that was mentioned, and including dark trace software and everything, we are kind of top of the division, because that's so important. That's the first one. And the second, Marc has outlined this. The human factor is decisive. Almost every incident we had, which we could stop at a certain stage, was related to human behavior. It was the partner who has been informed 25,000 times that you don't click on links like this. It has been people. We also do these tests. We put in like memory sticks in the copy rooms, and we have emails sending Gleiss Lutz with the triple S, so totally wrong, but you can win an iPad if you click this. 60% of the people were clicking on that because they're, oh, iPad, I don't see that this is wrong. And this is about the training, and it's always the human factor, and we keep on training our people by that. If there is a super criminal guy coming in from wherever, this is something you need to avoid by software. But the most important thing is that your people are aware, I am the weak part of the whole story. And this is on cybersecurity. This is the main message I'm always giving to the people. We can avoid 99% of the attacks by being trained properly.
Yes, but our life has changed. We are now in a world of agile working from home. How do you ensure that the same security level is kept? You cannot put any more this Chinese wall around the office that you could at the past days. So have you increased your security systems, and how do you ensure that you are not so much exposed there?
We have, certainly. I mean, this was kind of an uphill battle because, as all of you know, in Germany, it was the 13th of March 2020. So suddenly everybody had to go to the home office, which was by then just something people did occasionally. So we really had to work on not only on people being able to work from home, but also on the security. So we are very strict now. There is technical solutions that you are within the walls of the firm, even when you're working from home. But the second topic, I mean, I don't know, Marc, what you think about this. Something we don't touch all the time is confidentiality. I mean, certainly you sit at home and you are at the kitchen table and you have the most most important files of the industry on the kitchen table, and there are other people walking around, and certainly we tell people not to do anything. But if you delve into this topic too much, I had this with an Italian colleague a few months ago, where they said we don't allow home office because it's all too sensitive. And then you say, okay, but then we are dead if we don't allow mobile working. And the second thing is, if you consider what all of us do all the time, we take phone calls in the train, we sit at home, we are on a holiday destination and work on files while sitting on the sunbed. Probably you don't want to delve into that too much, because if you start thinking through, you probably need to be in the office 24 hours a day. And this is something that all of us don't want to do.
Well, some of us want, and it would increase our profitability. Time is running, so I'm handing over to Ilona on our last and not least subjects.
Yeah, our last subject is KYC and AML. We have Martijn Simovart and Martijn Lesterhuis who will elaborate here a little bit more, especially on what the reason is for KYC and DDD, CDD checks, and what is important for the KYC check, and also what is the legal framework, and examples of some relevant regulations, and what are the sanctions when it comes to KYC.
Okay, thanks, Ilona. What we're going to do, I'm going to do a short setting the scene, and then hand over to Martijn, who is going to explain much more. So how does it actually work in practice, and what are the issues you're dealing with? So if we look at KYC, know your customer, or CDD, which is customer due diligence, there are basically three important areas you need to think about. So actually, what does it encompass? So the first is, of course, is establishing your client's identity. And that's really what normally happens through the notary public. So we all know this, right? We know we need to have that information actually from the client. Is the client actually the person who says he is or she is, and also the function in that respect. And the second part goes much more to the background of the client itself. So rather than establishing the identity, you really want to focus much more on the client itself to understand, so what is the nature of the client's business? What are they doing? And where is, and it relates especially to transactions, where is the money coming from? So what are you working with? And that's quite important. And it doesn't have to be like Alexander already said before, you know, what kind of clients do we want to work for? But you really need to think, okay, in what context is this client working? That's one thing. And then at the end, you need to really look into the matter itself. So actually, what is going to happen? The transaction that's coming in. What actually is the client going to do? How does this transaction look like, and what's the reason for it? So you want to understand what are risks in the transaction, basically related to potential criminal activities. And I think that's the main point. So if you look at all the AML regulations and KYC regulations, the whole purpose is to avoid that you assist in financing criminal activities. And it relates a lot to money laundering. That's where it started. But you see also it relates to fraud, to corruption, to tax evasion, to what's also important, financing terrorist activities. So that's the whole background for it. Now, if you look at law firms, what is relevant? It relates, as I said, it relates to transactions in assets. So transactions in real estate, transactions in shares, and it's a lot more. Need to think about companies, crypto, but also expensive assets. So that's what it focuses on. So it's not focusing on litigation. And that's always the discussion. Where can we work for our clients, and for whom is the KYC the most important? It is about financing basically the system. So that's what you see. It's also coming out of the banking sector, and that's very much where it relates. So it's not relating to litigation transactions. To litigation itself, but it's focusing on the transactions. That sounds all, I have to say, quite clear, but of course what you see is you can say, okay, litigation, not an issue, we can act. Just say it simply. transaction, okay, now we have to be careful. But the point is, of course, in practice, it's not that simple. So often what you see is if you start with a client in, let's say, a litigation, and suddenly that client moves on and says, okay, we want to do something else with you, you need to do the whole process again. So that's one thing you need to be aware of. But also what you can understand as well, maybe you're acting on a quite simple matter for a client that looks at it quite simple at first, no issues, but moving along when you're in that relationship, things turn to become a bit more different. That's where you really need to be careful. But that's also what's quite important. And I think Marc already explained that before as well. When you're in the process with the client, of course, you don't want to be part of, let's say, criminal activities, but you also have this client relationship. And that's really the difficulty in this whole process. From the start, it can look very black and white and it can look easy, but as long as you're in a client relationship, you always need to be careful. So I think that's quite important. And what you see in terms of KYC checks, there are all kinds of regulations and potential checklists that you need to be aware of. So you want to check on activities, you want to check on high-risk countries. There are also what they call red flag procedures, which has predetermined warning signs. Those are all the things that basically your compliance department or the people who are involved in are looking into this. I think what's especially important, and mentioned before as well by Karl, is the PEPs, so the politically exposed persons. If you have these lists, and just to explain how complex it is, there are, you also have sanctions lists. There are over 1,000 sanctions lists worldwide that you need to be aware of and that are being updated constantly. Now, one of the things is these lists with publicly exposed persons, or sorry, politically exposed persons. Those are people all over worldwide who are having prominent public positions. And that means that governments say people in that position are easily exposed to bribery or corruption. So that means you want to check your lists also on the people. Are they a PEP, as you call it? And that's a warning sign. You really need to dive into to that person as well. So you need to be extra careful. So yeah, I think in that respect, it is quite complex. And maybe to add as well, there is no, we said it before as well, it's there's not one solution. Already, if we look at the legal framework, especially already in Western society, even in the EU, where you have the anti-money laundering directives, you could say, okay, the EU is a lot of countries, there are directives, so it should be more or less the same. Actually, it isn't, and I think Martijn will explain a bit more about it as well, because in the EU, the directive sets basically minimum requirements. So countries locally can adopt those as well a bit. So that means always each new client coming in, each new transaction coming in, you always need to be careful and you need to look at it. It's in that respect also already quite cumbersome. And then I'm not talking about regulations in all kinds of other countries. But so yes, I think it is complex. You need to think about it because sanctions are quite heavily. Not seen it so much in law firms, but already in banking you see a lot. Quite nearby, ING Bank got a fine of almost 800 million euros for not complying with anti-money laundering regulations. And even the CEO, who is now the CEO of UBS, there was really a discussion whether he would be prosecuted. Because at the end he was responsible. Now that didn't happen, but it really shows how important this is. Also, as a law firm, you need to be aware of this and you need to comply because sanctions and also reputational risk can be severe. So I think that's maybe at a glance.
And you were mentioning what are the high risk countries. Maybe you can elaborate a little bit more on that. And also you said fines you haven't seen in the legal profession, only in the banking sector, but I would be curious to hear as well whether you know maybe in one case or another case where, you know, there was some prosecution or criminal case against a lawyer who was not following the KYC.
Yeah, on the list, I don't have a clear example yet, but I'm quite sure this will come up, because you see it's falling out of legal is basically falling banking in this respect, and that replies also to that's also the same for all kinds of other advisors around the financial sector. So that's and maybe any other of the panelists know such an example that would be interesting to hear. If you look at the high-risk countries, especially what you see, there are lists of countries, and these change on a regular basis. And basically these are countries where more governments, and I would say, if I look in Western society, the EU or the US or other countries look at and say, okay, these are countries where you need to be aware of bribery or corruption. And those are basically countries all over the world. So it's not on a specific region, but if you look at the latest list, it could be in Africa, it could be in Europe, it could be in Asia, it could be in South America, for instance. So it's changing. So it's really where the local countries say, if we look at you doing transactions with these countries, we think the compliance levels of those countries are not up to par. So that's why they're on the list.
Thank you, Martin. So Martin, can you tell us a little bit more what KYC means in practice for a lawyer?
Yes, thank you, Ilona, certainly. And like Martin already mentioned, it's really a complex issue, and there are so many details in it. And there are rules, of course, there are directive in EU set up, and but the country regulations are still different, and it's actually a lot up to discretion on your own firm to set up these rules and to what you kind of want to establish and comply with, because and the guidance in this regard is not too detailed, but basically what is really important is you determine what is relevant for your organization, to your business, and it's really important that you implement those in practice. And of course, as more comprehensive these are, you kind of limit your potential exposure to kind of liability if you are non-compliant. So yeah, kind of in our firm, we have a really lengthy and comprehensive rules set up, and we have also a compliance officer in place, because we are around like 35 partners, 200 lawyers in a firm. So we really need to make certain that that these procedures are in place and being fulfilled and implemented. But I think the first thing you should do really in setting this up is to kind of determine so-called the risk appetite, which you kind of defined by relevant jurisdiction of the client, by specific fields of industry the client is all involved. Is there kind of a high risk industries, for instance, the virtual currency or some others? So then you define it by type of transactions, and then eventually by person, like the politically exposed persons, which have been already mentioned. And then you kind of evaluate those all jointly, and then based on this, determine if you'd like to take a client on board or not. And then in addition to this kind of specific things, you should always consider in mind the reputation risk as well. Although it might not be strictly non-compliant, you need to kind of always have that back in your mind. As regards this politically exposed person, when we just want to add what Martin said, that there is of course a kind of list available of such persons, and there are organizations or kind of companies providing assistance in searching such persons. But what makes it really complicated, because in addition to this politically exposed persons, the same applies to their associated persons and family members. So basically, when a family member of a politically exposed person would kind of approach you and wants to become a client, kind of the same, so the same fiduciary obligations and measures and more high risk is implied to that person as well. But in this regard, to kind of ascertain that if that person is associated or like a family member to the politically exposed person is of course extremely extremely complicated and very cumbersome process in practice, and you really need to kind of more or less get involved in a detective work, or really need to kind of hire perspective kind of search company to see that. So yeah, there is nothing white and clear, but it's kind of all these things need to be kind of considered in complex. Yes, and of course having like a special compliance team in a firm to assist you with this, that's really helpful, and because otherwise you simply will not be able to kind of handle that yourselves. But of course, it's been mentioned earlier in the very start of our webinar that it lot depends on the size of the firm and of course your resources and etc. But most important is that you really are able to implement it. Yeah, again, maybe one aspect, but also Martijn mentioned that of course it's really is relevant for these sort of the transactions and not the litigation work. Kind of for transactions, of course, it's also like pretty open end what is considered as a transaction. Of course, it's very plain that it's a kind of real estate transaction, share transaction, or setting up a company, or of course when you kind of act on behalf of the client on the basis of power of attorney. That's the biggest risk what you can take, and there you really need to be really certain. But again, you need to set like these internal rules and establish what you internally in your firm consider as a transaction. And then for instance, in our firm that that guidelines are like almost 10 pages long, so I'm not really going in all the detail in this, but yeah, these things are complex and you need to kind of establish on the basis of your business and your firm. Maybe from practical point of view, like a few examples which we have come across, and really what you maybe need to deal, and you can make your life maybe a little bit easier. But of course, it's again depending on your risk appetite and what the procedures you have placed. But let's take, for instance, that you are being engaged by another firm, like a foreign firm, which happens a lot, and not directly by the client. Then, of course, if that firm approaches you from the EU region, then you can kind of assume that the same terms and the same fiduciary duties will apply to them as to you, and you can kind of ask them if they have performed already the KYC search, and also that if they will like provide you with the relevant documentation if the need may be, and also you may also request or ask the documentation from themselves. In this regard, you may like avoid going through the same process twice, so it makes your life kind of easier. But of course, if this kind of request comes from a non-EU firm and kind of then either red list, but there is no white list. White list used to be like 10 years ago, but there is no longer a white list of the countries. Then it's really up to yourself to first determine what the rules are in that jurisdiction that firm is obligated to follow, and these are kind of enough for you as well, because eventually all this risk relies with you. But yes, if you're kind of satisfied that these are fine, then and your risk appetite is compliant, then you rely on those.
Yeah. So any other questions maybe from the audience, because I think we slowly are approaching the end of our webinar today. I think we have nothing in the chat. Karl, do you have any further questions to our distinguished panel of speakers?
No question, but a warm thank you to our brilliant speakers. It was an extremely interesting webinar, and hope to do it soon live and not via internet.
Yeah, also from me, a very, very big thank you to all of you. It was really great having prepared that with you and being today online with you all. And as we mentioned already earlier, might be that we will have one time in-person conference here in Moscow as well. And we would be very happy to elaborate more on this topic. I think there's a lot more to say than we did today. We touched just a bit upon a couple of the items, but yeah, this is what I can say. Still, there is the conference on the 3rd of December. We have not yet decided whether it will be an online or offline conference, but we will keep you informed on that. And thank you again for all the attendees for having followed us till the end of that webinar. And special thanks to Karl Hepp, de Sevelinges, who was assisting me in moderating and preparing that webinar together with our very famous speakers. Thank you so much.
Thanks, Ilona. Zekely.
Thank you. It was wonderful. Thank you very much.
Thank you. Bye-bye.
Bye.